This is Dan Turchin from AI in the Future of Work. Welcome to this special AI in the Law edition of AI in the Future of Work. As always, we're using 11 Labs to digitize my voice for these special episodes. The real me approved the content and, of course, approved the digital twin. AI isn't just transforming how we work, it's redefining how we interpret ownership, ethics, and responsibility, from intellectual property to legal compliance to the way lawyers practice. The intersection of AI and the law has become a topic of daily debate. This month, we're revisiting insights from 5 incredible past guests: Robert Plotkin, Jim McKenna, Scott Stevenson, Rafi Farouk, and Tamara Steffens, each exploring a different side of how AI is challenging established laws and forcing us to reimagine the entire legal profession. Let's start with the foundation. Who owns what when AI gets involved? Robert Plotkin is a patent attorney and co-founder of Blue Shift IP. He spent years helping innovators navigate the complex relationship between law, technology, and creativity. In this clip, Robert explains why legal teams must rethink intellectual property rights in the age of generative AI, from who owns your prompts and data to how courts may soon treat AI-created inventions.
These days, I'm doing about 8 executive briefings a week for leadership teams that are trying to figure out what their generative AI strategy is. And among the topics, we discussed the social and cultural implications, and we certainly discussed the legal implications. There's a very high-profile example in Samsung where their engineers were inadvertently feeding training data that was proprietary back to OpenAI. That's a no-no. And that frankly throws a lot of organizations realizing that there are implications that they don't fully understand. I would love to just start with an open-ended question. What do and don't we know at this point about how the law is or potentially may treat generative AI?
A lot of questions in there. You know, the one that you just mentioned is who has the rights to the input to generative AI. That is, for the most part, under the law, a contract question. So read the end user license agreement carefully of any AI tool you're using, such as ChatGPT. You know, I believe that generally OpenAI has made it clear that this is a publicly available, mostly free tool. You can pay for higher levels of service from it. But, you know, for the most part, you should assume when you're using a tool like that, that any input you provide into it is going to be accessible to OpenAI, is not going to be proprietary to you. And that, as you said, it seems like not everyone at Samsung was aware of that or attuned to it. And so already, though, you know, there are responses to this. There's going to be market responses to this, you know, companies providing tools where maybe the technology isn't much different from ChatGPT, but the end user license agreement is different because customers, you know, corporate customers and individual customers will be willing to pay for a product where, according to the end user license agreement, the vendor agrees, you know, to maintain the confidentiality of the customer's input, or agrees not to make use of the input in training models. I mean, I know that as in the legal world, I've seen lots of AI tools that have been marketed to my law firm over the years. And the first thing we always ask is, if we provide input into it, can you use that to train your model? And one reason for that is very often, probably your listeners are sophisticated enough to know, often AI models do what's called memorizing the training data, which means they might just spit that input right back out to another customer. I know I barely touched on the questions you asked, but I'll just list a couple of the other topics without going into them. Who owns the output of something like a Midjourney or you know, Chat GPT-based images? What rights do the owners of the training data have to the outputs? I know there's a lot of controversy going on now with images because of image generators using, copyrighted artwork, and spitting out output that is pretty similar in some cases to the copyrighted training data. And I suspect where that's going to go and how it's going to get resolved is probably by a bunch of licensing deals, just like in the music industry. That's how things have panned out. But who knows? A lot's to be determined there. And there might be some copyright infringement lawsuits by copyright owners against companies like OpenAI before things settle and the dust settles.
So you hit on one of the most important topics, exactly what you said. Can I patent work that was derived from an LLM, a large language model? And look, we're 6+ months into this experiment. GPT and other AI models have been around a long time, but since the commercialization of ChatGPT, just the public's imagination has just gone wild in a way that's exciting. What do we know so far? Have any cases been decided that maybe would be good coaching for listeners?
Yeah. So, I mentioned the copyright side of things. On the patent side, I think it's unlikely that we're going to see patentable inventions coming out of ChatGPT directly. By that, I mean someone just asking a question to ChatGPT and getting an answer out, which on its own is a patentable invention. I don't think ChatGPT is likely to do that.
Next, we turn to the operational side of the law. Jim McKenna is Chief Information Officer at Fenwick & West, one of the world's leading technology law firms. He's responsible for keeping innovation moving without crossing legal or regulatory lines. In this segment, Jim shares how law firms balance compliance and creativity. He explains why the best legal innovation requires ironclad audit trails, strong governance, and the courage to modernize even the most traditional systems.
So one of the things that's unique about your role is, as you alluded to, heavily regulated. I mean, you need ironclad audit trails. Everything could potentially be discoverable in a court of law. But in the meantime, part of your competitive advantage is being able to innovate and being able to deliver that exceptional quality of service to the end client. Do you ever think about those as being kind of two levers that don't always turn in concert? And how do you when you're making decisions, how do you think about managing both the risk from a regulatory perspective without wanting to be a constraint on innovation for the business?
Sure, it's another excellent question, and it's a difficult one to answer because there's no perfect answer. If we were so risk adverse and we drove our clients to go back to using pencils and paper, we would be out of business. So that's one. If we look at the fact that we have clients that want to collaborate with us and they want it to be as easy as possible, the challenge actually is what's a solution that enables that to occur and we can maintain the security requirements, the confidentiality requirements, the availability requirements, all those type of things, and be able to attest to it later. Here's what happened, when, where, why, how, those type of things. A key component of that is clearly understanding what is the need and then breaking it down into how we will accomplish it. And ultimately, what is the process that we will put into place so that whenever a person is delivering that service the next time, they are repeating a known standard with customizations as needed for the client and such. But we have it recorded, we can present to it, we can attest to it. And in a way, there's an old adage, when you tell the truth, you don't have to remember what you say. If you do the right things with the right systems, the audit logs will prove that we did it correctly. And then along the way, we'll just sometimes discover, we need to make a tweak, or the government will make a change. There's a new law. We might have a client that specifically has a need. We got to have the flexibility as well to be able to meet that need or that change. And from this point in time forward, or for this client on that matter going forward, we do it this way, and that's recorded. That's a long and rambling answer, but if you get used to the idea of understanding what the deliverable is and then re-engineering the equation to here's how we can deliver the deliverable safely, securely, and reliably, you can get it done. That's kind of fun.
It drives me crazy when my bank requires some kind of paper form or I need to rely on snail mail for something. I can't remember what the service provider was. I think it might have been my credit card company or something. Asked me to fax something.
Oh, wow.
And I tried my best to be polite, but I wasn't entirely polite in my reply. Are there examples like that where maybe, that credit card company or the bank or whatever is somehow regulated to enforce, some just arcane process for historic reasons, where in the legal field, you have to defend doing something that as a technologist, delivers a really poor experience, but you have to say, we do it just because?
The answer to all of that is yes. There are institutions that still require data in a particular format that the average person with a smartphone might find frustrating. But we don't have the ability to dictate what the new standard should be. We have to comply with the inevitable. So there are a couple of fax machines that are still present within Fenwick and West. Interestingly, we've migrated all of those services to the cloud. So if we look at it from an algebraic equation, we're doing all the right things, but the deliverable is something archaic, but it works. And we don't have the infrastructure to maintain or the systems to keep alive or the electricity being consumed there. So that's one small example. Another of which is occasionally we will have a process, and I think this is a challenge for every institution, particularly law firms. We will have a process, we'll have a service, for whatever reason, is popular. And it works well enough. It works well enough to the perspective that people don't want it to change, even though other things have marched forward. Eventually, we'll get to the point on those things where the end is here. We now have to adjust. It could be a security update. It could be an incompatibility. Once in a while, things change from a service delivery standpoint to third parties where this is no longer acceptable. Great, and then we can use that as a catalyst forward. It's really easy to focus on the brand new and what's interesting. It's really easy to get rid of the things that people don't use and don't like. Sometimes it's hard to get rid of the thing that just works, but it's inevitable.
Legal AI isn't just theory, it's already transforming how lawyers work. Scott Stevenson is the co-founder and CEO of Spellbook, an AI tool designed specifically for lawyers. He shares how technology can enhance legal review without replacing human judgment. In this clip, Scott describes how Spellbook keeps lawyers in control, why verification and citations matter, and what responsible AI looks like in real legal practice.
So we can't be having this discussion about AI and legal without thinking through what it means to exercise AI responsibly. And I'll just tee up the topic. I'd like your thoughts on who is responsible if Spellbook AI inserts something that it made up, or that's probably too extreme of an example, but does something, makes some automated decision that's accepted by your customer that ends up leading to some kind of damages, financial or otherwise. Who's liable?
The lawyer is. And it is our responsibility as a company to build a product that does not put them in a position where they feel like they're going to blindly trust this thing. And so everything we build is built to create sort of what I would call an electric bicycle for lawyers. So it's not, they're still in the driver's seat. They're still steering. They're still choosing what to accept, what to reject. And we try to create a user interface that is not just blindly telling them things or asserting things confidently that might not be true. So an example I'll give is in our chat, when you ask a question, you're going to get citations back with that. And it's going to be like, hey, to answer your question about this 200-page document, here's my answer. And here's where I found the information that I used to give you the answer. And it's the lawyer's responsibility to click on that citation or to look at that citation and be like, yeah, that makes sense. And it's our job to build a tool that can be used in that way where it's very easy to verify answers. I think the challenge with a lot of the early language model products is that they couldn't go and look up information. It was all based on memory, basically. It's like, you asking me now, hey, Scott, like answer this really complicated question about, legislation in the US. And I'm not allowed to use the internet. I'm not allowed to look anything up. Well, I'm going to give you a crappy answer. And so what really changed is providing AI models the ability to look up information and cite information that allows them to be a lot more accurate. So I think lawyers should use tools that do that. The other thing we do in the Spellbook interface is we have a contract review UI, and everything that we suggest is called a suggestion. And there's a button you can either accept or you can reject. And if you reject it, you can leave feedback on why you thought it was a bad suggestion. And I think getting lawyers in that mindset of accept, reject, this is a suggestion rather than like, this is what you have to do. I think that's our responsibility to create a user experience that's like that.
Shared in the fun fact about how increasingly, as we talk about agency, agentic AI, and giving more prominence to the I than the A, the intelligence part than the artificial part, we start to insert, again, I have an opinion here, kind of damaging language about how the AI is like a human and it's doing a job like a human. And there are companies that are putting the bots on the org chart and there's talk about, should they pay employee taxes on it's a slippery slope. So it seems like you've gone out of your way to say it's a co-pilot. Here's where it's getting its information. It's like just phenomenally good at pattern matching at scale, and it sounds super credible, but like that's what it does, and you're always responsible for what decisions you accept and reject from the AI. Play this scenario out. Do you think that paradigm will persist, or can we ratchet back the temperature when it comes to assigning agency or sentience to bots?
The ideal interface to work with these tools, even if it's agentic, is still sort of here's my suggestions. You still have to manually accept or reject them. And even if you think about how a senior lawyer works with a junior lawyer, the senior lawyer is actually liable at the end of the day, not the junior lawyer. The senior lawyer is the one who has to review and accept or reject the tracked changes that the junior lawyer has submitted. And so the first thing I'd say is, regardless of whether it's human-like or not, you still have to kind of treat it like a very junior employee who's like, they are not the ones liable if something goes wrong. It's the manager or the senior person who's sort of the one who's saying, yeah, putting the stamp on the work or reviewing the work and putting a stamp on it. I think it's confusing. I think there's the word human-like, or the compound word human-like, is like very has a lot of meaning baked into it, and I think it means a lot of different things to different people. I don't like the idea of sentience. Like, I don't think these systems are sentient, or that we should treat them as sentient. I think that's definitely misguided, and that's a risk of using terminology like that. I think what people are trying to convey when they say human-like is like, you can assign it a little project and it can pull it apart into a plan and accomplish those steps and review its own work and give you something, from a small prompt and a little bit of input. It can give you something back that feels almost like maybe close to what like a very junior lawyer might give you. And I think that's what it's trying to convey. Is it the best way to convey it? Probably not, because it's such a loaded term that, conveys sentience and there's other things. And I don't think that's the best thing to convey. We mainly use the word agentic. And what we mean by that, we just define it as like an agentic system is a system that can take a broad objective. It can break it down into a plan. It can do the work or the steps in the plan. It can check its own work, and then it can go back and fix its work if it finds a problem, or it can adjust the plan as needed so it doesn't get kind of stuck. And we say if it can do these four things, it's agentic, and we mainly leave it at that.
From document review to contract generation, AI is accelerating every part of legal work. Rafi Farouk is the founder and CEO of Genie AI, a company that's building intelligent systems to draft and analyze contracts. In this segment, Rafi discusses the legal risks of false positives and negatives, how Genie builds trust through quality and accuracy, and why the future of law will depend as much on ethics as on automation.
One of the fascinating things about the space that you're in is that the cost of both false positives, the AI recommends something that's wrong,
or false negatives where maybe there's a mistake, an error in the contract that it misses, can be enormous. I mean, lives can be harmed, laws can be violated, financial penalties. I can only imagine. What do you think about in terms of the responsibility that Genie has for the downstream implications of the contracts that Genie AI proposes?
Yes, this is also a great question. So for us, false negatives are a lot worse. So if we miss, let's say we have one algorithm that spots risk in documents and highlights red flags and yellow flags in a traffic light system. If we miss a red flag, that's potentially drastic. Whereas if we say something is a yellow flag and it's not the end of the world. So, a simple approach is we do make our algorithms a bit more sensitive than perhaps needed. Of course, it's a balance because we want to save people time as well. So, legal is fraught with these trade-offs. Another example is for those who write legal documents know that sometimes you want to keep language a bit vague just to let the document be flexible and take into account different scenarios. But then most of the time you want to be specific because that's going to hold up in court more clearly. So there are all these trade-offs in legal, and there's often not an absolute correct answer. But I would just say, again, that is actually a good AI problem because AI has millions, billions of parameters and can take all those factors into account to make a final decision.
To that point, it's always worth considering when we look at harms that AI can do, the corollary harms that people can do, because it turns out people are error prone as well. Yet, somehow it's easier to scapegoat or assign blame or penalize the AI because it was an automated decision. One of the things that a lot of vendors, AI first vendors, have started to do is actually indemnify the customer in case anything the AI generates ends up creating legal issues. If you thought about it, is it something your customers request, or how do you think about defending the integrity of the AI-based, the automated content?
Yeah, we've thought about it, especially in the form of insurance. So we have extensive insurance ourselves. We haven't to this date made this available to the customer. Rather, we focus on quality. For us, we've always found trust is a major issue. And the main factor that solves customer trust is just simply quality. And so for all our AI features in the product, we have the usual thumbs up, thumbs down, feedback mechanisms after each feature. And typically, the way we do it is we basically track only lawyers and attorneys, their feedback on these particular features. And we typically average around over 91% accuracy on most of these. So we just track is that going up or down and keep that as high as we can.
You recently recorded an interview with the BBC and you were asked this question, and I suspect you get this question a lot, as do I, about the impact of what Genie's doing on jobs. It's automating a lot of the menial work that a paralegal would do, sometimes even attorneys would do. And it's hard not to consider, the moral, the social obligation that you have. And if you play out when, Genie is wildly successful, what does that market look like for legal services?
Yeah, it's really interesting. I was reflecting back on the TV interview where the reporter on national TV asked me 3 times, what's going to happen to jobs and so on.
You gave a brilliant answer, by the way. That's why I asked you the question. I want our audience to hear your perspective on that.
Yeah, no, I appreciate that. And I think it is an important question. It's multifaceted too. The obvious answer is that, or the immediate answer, which is perhaps the boring one, is that our clients, who are typically in-house lawyers, they typically want to do the exciting work of the next investment deal, the next M&A transaction, advise the CEO. They don't want to do the day-to-day NDAs and employment contracts. And that's where we come in. But, what's more interesting is what is the greater impact on jobs? One thing I will say is, and this is where it gets philosophical, I actually think the objective function of society, which is productivity, GDP growth, I think that served us well for the last 50, 100 years. But I don't think it's going to serve us well for the next 100 years. Because if all you want is endless GDP growth, all you're going to get is endless AI, endless productivity, and endless growth in countries and borders and ultimately conflict. Because if everyone's having more, something has to give. Nature works in balance and cycles. So we need to find that same harmony in society, that same balance, rather than a more is better paradigm.
Finally, let's explore the future of legal careers. Tamara Steffens is managing director at Thomson Reuters, where she invests in technologies that are reshaping the legal profession. In this clip, Tamara discusses how AI is transforming legal education and law firm workflows. She explains how automation is freeing young lawyers from repetitive tasks and why firms that resist AI risk falling behind.
What the introduction of AI means specifically for the legal industry. And just for context, recently we had a guest on the show, a guy named Jim McKenna, he's been a CIO in legal firms for 30 years.
Wow.
And just a walking time capsule, amazing person, a historian, and just he really educated me and our audience about some of the opportunities and challenges of introducing AI into the legal profession. So let's say from your seat, presumably you're an AI enthusiast and looking at opportunities where AI will benefit the legal profession. And certainly as a client of a very high-priced law firm, I hope that PeopleRain will benefit from that trend. But let's take the other side of that. If I'm an attorney or maybe a kid in law school, how should I be thinking about what AI is going to do to the career that I had planned?
Yeah, I think they're coming in a really fortunate time, right? Because a lot of the stuff that first-year law students, second-year law students had to do in a firm wasn't very fun, right? It's, this is the dregs, if you will, of the work that is available in the law firm goes to the first and second-year law. A lot of that is going to be automated, right? And so I think from their perspective, they're going to be able to do much more of what they were trained to do in law school much faster. So it's going to be, I think, far more interesting if you're going to be a lawyer, that you'll actually be doing real work much faster and adding to the revenue of the law firm. If you think about it, right now you have these lawyers, junior lawyers, if you will, go and do all this research on citing cases and, putting everything in, the research. It takes, days, if not weeks or months on some cases to pull this together. That can be pulled together now in hours. Now you still need somebody to go back and check it all, right? Because no lawyer is going to just wing it and just say, this is perfect, right? So they're going to go back and check it all. But I do think it's going to save a lot of time, right? And so those early in career lawyers are going to be doing much, much more interesting work, much faster in their career. And I think law firms will, a year ago, we had a conference it was 2022, December of 2022. It was the Legal Tech Fund conference. It's in Miami every year. We sponsored it the first year. We sponsored it this last year. We'll probably do it again this year. And the lawyers that were there were like very hesitant. Maybe we'll use it for this little piece or that. And we actually met Spellbook there, which was one of our first legal tech AI investments. And they're amazing. And a year later, the same panels, same lawyers, judges were there. The conference was sold out, within a matter of weeks. And everybody was like, no, like a law firm can't not use AI, right? Because the speed to get things done is so much faster using the technology. You've got to double and triple check it, right? You got to know the sources. Exactly what you were talking about earlier in the podcast is for your company, knowing the chain of where things came from is, critical not only in HR, but in people, but also in legal, right? So I think that'll be, people are going to have to make sure they understand where it's coming from, but it's still going to speed things up drastically.
I frequently say AI is good at doing tasks, but not doing jobs. I will make an exception, however, for paralegals. I think there's a lot that a paralegal does. I know from firsthand experience as a client of high-priced attorneys, that the compliance work, the filing, things like that, I do believe could be largely automated with AI. Is that consistent with what you're hearing?
Yeah, 100%. Yep. We hear it all the time. And we see it, right? In some of the products that are coming out, even some of the products that Thomson Reuters has, as we enable them and add AI to them, it's going to, and you have to think about our own products. We have the sources, right? So you're pulling from Westlaw, you're pulling from Practical Law. We know those sources are good, right? So the answers that are going to come out are going to be correct. So from that perspective, I think, it really does go back to the point that you talked about early on, is just knowing where those sources are, where they're coming from. But yeah, a lot of those tasks are going to be automated. I think there's still going to be paralegal jobs, right? Because there's still work that can be done, harder work, less mundane work, some of that, filing, like you said, and you can automate a ton of that work.
AI is forcing us to rethink the very fabric of law. Who's accountable for an algorithm's mistake? Who owns a model's creation? And how can we ensure that technology serves justice rather than complicates it? The legal system was built on human judgment. Now, as AI becomes part of that process, our challenge is to make sure the law evolves without losing its humanity. If any of these insights inspired you, listen to the full episodes. Links are in today's show notes. And if you know anyone curious about how AI is changing the legal world, share this one with them or leave a comment with your perspective. Thanks for listening to this special AI and the Future of Work compilation. Until next time, stay informed, stay ethical, and stay curious.